You filed your matter in this court, you also filed some documents. Can you remember that?
Yes, I do.
Now, there is a document that you filed called a list of documents. It's dated the 8th of August 2019. I assume you still have your copy with you, yes?
Yes, I do.
My lord, we have listed 23 documents to be tendered. And I would like to apply now, based on order 14.2 of the rules of this court, that if my learned friend consents, all the documents will go in, and there are documents that will go in, and when you get to the address stage, if they have any issues with any document, they will raise them rather than go piecemeal. I don't know if that will be convenient for the court.
Yes, Mr. Marjorie, what is requesting is that you reserve your objections. The parties reserve their objection, and they be raised at the final written address.
No, my lord, we are objecting to his application.
So you want to have your objections noted.
Yes, my lord.
So it would have made it easier for everybody for the documents to go in, and during the final address, anyone that is when objection is raised and it's upheld, the document will not be utilized.
As the court pleases, so if I may inform the court, my lord, as at the last adjourned date, these documents were not before the court. We have never had access to these documents. Allowing me to go in with the intention that we are going to address it as written address. We don't even know what's going into the they just said 23 documents. We have not seen them. So there's no
You have not been served with the documents. Say you have not been served with the documents.
Yes, some of the documents.
Some of them.
Yes, my lord. We noted at the last adjourned that most of the documents were not in court. Even though they have it in court, they said they were going to oblige us with documents. So we jump in the gun and allow the document to go in. We even know what we're addressing at the final written address. We just said he had 23 documents, and we don't even have up to 16 documents.
Okay, you have the list of documents.
Yes, my lord.
Which documents do you not have?
As the court, please.
The document number 7 on the list of documents. There's a letter on signed employment terms and conditions dated 1st March 2011 and an addendum dated 1st November 2011.
Yes. You do not have that?
Yes, my lord.
Okay. Which other one?
We don't have number 13, 14, 15, 16 on the list.
These documents were ticked last time
Yes, my lord.
because I think the same issue came up.
Yes,
And,
my lord.
because I have 7 marks here. I have, did you mention 12? No.
No, my reservation about 12 is there are so many emails here. So we have checked, the emails are not tallying. So I
The,
won't know
the emails are not what?
the emails dated here. It's not following the emails we have. So we are not certain of the emails.
So the email dated 16, you do not have the email dated 16 July 2015 and 22nd July 2015.
Yes, my lord. And we have other emails that were not listed, but are in evidence. Because it has so many emails here. Those are part of our
You also do not
observation.
have number 12.
Yes, my lord.
You do not have number 12.
And we don't
What did
13.
you number what? 13, 14, 15, 14, 16, and 17.
Yes, my lord.
Chief, at the last date,
Yes,
it was agreed that you furnish the claimant with these documents that they do not have. Because
My lord,
their point is that those documents were not front-loaded, were not served on them. And if the documents are pleaded and are relevant, so they become admissible. And we will not reject them on the ground that they were not front-loaded. But then the defendant is entitled to know the documents is coming up against.
yes,
So that was why we asked that you serve them with these documents, and you still have not served them.
okay, my lord, if I may address that, first, the issue of whether they were served or not. I had mentioned at the last agenda that what we did was serve the registry of this court, serve them with a bundle that we compiled and the lordship also has. Now, my bundle has all the
All these
documents
documents.
except numbers 13, 14, 15, and 16. And I had mentioned to my learned friend this morning, because he also came to me, he didn't mention any other document except like 13, 14, 15, and 16. And I said to him that even the claimants, we do not have them because they are voluminous and they are coming from the bank. I had explained that to him this morning. So 13, 14, 15, and 16 are not in this one. But every other document we listed in our list of documents are here. And I had humbly requested my lord at the last agenda to confirm that the court's bundle has all these documents with the exception of 13, 14, 15, and 16. So, my lord, what my learned friend said concerning the fact that there are other emails in the bundle that are there but are not on the list. My lord, with respect to my learned friend, even when we list documents, at trial, we might decide which ones to go with and which one not to go with. It doesn't affect the fact that we can tender the ones that we have. My position, sir, is that the only documents not in this bundle are 13, 14, 15, and 16. And we are working with the banks on those 4 sets of documents, getting them into court. And I had mentioned this to my learned friend this morning when he came to ask for those documents. What I thought he said, which he clarified to me that wasn't the case, was that he does not have any document at all. Because I would have said, well, you filed in the registry of the court, they served you, the presumption is that you have them. But he said, no, he's talking about the bank document. And I agreed with him that even in court here, I do not have those 3 or 4 documents to tender today. That was what I told him in the morning. So except of course it says, and the court's copy confirms that 7 and 12 are not in this bundle, then with respect, I don't see the objections.
So, Mr. Majori, are you saying you do not have 7 in your bundle?
Yes, my lord. The
7 is unsigned employment terms.
Yes. What I'm trying to draw the court attention to is the document. We have had cases where the document that is being presented in court at trial is different from what is front-loaded.
So have you seen what is being presented?
I haven't seen that. I'm saying I can't allow it go in without seeing those documents.
But it will be shown to you. No, which one are you? Okay, you're saying you have not seen number 7 at all.
My lord,
My lord,
No,
would
if
like
you have
to-
been served number 7,
you can't hear me, Lord.
we want to go through the list again. And there's employment terms and conditions.
Yes, my lord.
There is the one I have here is signed.
Yes, my lord, that's the one we want to tender. It's signed. The name there is Obonugwa Arabia.
Arabia.
Yes, my lord.
Do you not have that document?
We have the one that is signed with the second and third defendant. What they said is unsigned employment terms. It's not before the court. That's what we
Okay,
are saying.
number 7 unsigned. What is here is signed, and the date is 22nd November, which means it's not tendering number 7. What do you have another document that is dated 1st November 2011? Chipadeni?
My lord, the one we have on the list
Yes.
are dated 1st of March 2011 and 1st
November.
of November 2011.
Is that what you have in your bundle?
Yes, my lord, the one I have in my bundle, 1st of March, my lord will see from page 1 of that employment terms, it says that this amendment is effective 1st November 2011. And the one I have to tender, this amended, oh, my lord, just a minute. Just a minute. I think I see
Looking
my
at terms
editing.
and conditions.
My lord, the one for deep drill, the page before that one, is dated 1st of March 2011. That's in the bundle.
In the bundle.
Yes, my lord.
If just let us just follow this. Your document.
Yes, my lord. The one that has the title deep
The
drill.
first document there is the ruling of this court,
Yes, my
Yes,
lord.
my lord.
followed by affidavit of change of name
Yes, my lord.
Yes, my lord.
and the further affidavit, followed by an email,
Yes, my lord.
Yes.
2008. Then there's an attachment to the email.
Yes, my lord.
Then there is offer letter dated 30th May. That's
Yes, my
number
lord.
5.
Yes,
We
my
have
lord. Yes, my lord.
then we have the claimant's email communicating timesheets. There's an email dated 4th October 2016.
Yes, my lord.
So that's number 6. Then we come to deep drill employment terms and conditions.
That one is the unsigned one. Yes, my lord. That is the unsigned one.
But
It's
are they,
dated 1st of March 2011. My lord can see it from.
are they,
We
there
don't
are
have
3
that.
pages of it.
No, my lord, there's just one page.
One
for
page.
Deep drill, and there are terms attached there too.
Okay, now therefore, that this amendment is effective from
Yes, my lord, which
10th
is why we have 2
March.
dates for number 7.
I don't have that, my lord. After the email of October 4, 2016, what I have is an attachment dated 30th September 2016, a further email giving a breakdown of
Sorry,
allowances.
after the last page of that email,
Yes, my lord.
after the last word there is email, humble energy.com. After it, the very next thing is employment terms and conditions.
Yes, my lord.
That is number 7.
Yes, madam.
The, is it the one dated 22nd of November 2012?
Well, let us start from the first page of it. If you look at the third paragraph, now therefore, that this amendment is effective from March 1st, 2011.
I don't have that, my lord.
But you have a document signed by Ogunwa Adubea on 22nd of November 2012.
Yes, my lord.
Okay. Before that, 2 pages, there are 2 sheets of documents before it. Yes.
Yes, my lord.
So that's the first page where you have employment terms and conditions underlined. On
Yes,
that
ma'am.
page, the third paragraph. Now, therefore,
Yes, my lord.
that this amendment is effective from March 1st, 2011.
As court pleases. Yes, my lord.
That is number 7.
As the court,
As
please.
court pleases.
That is number 7. Then the addendum. Is the addendum the next page? The addendum, now therefore, that this amendment is effective November 1st, 2011.
1st November. Yes, madam.
As
Yes,
court pleases.
that's so these 2 papers are number 7.
As the court, please.
Yes, my lord. They have said it must time, and we are saying what is here is signed. And it
No,
was signed.
we are just looking at the sheets. We have not come to the page that is signed.
My lord, if I can clarify,
Yes.
I think the confusion arises from illegal, inelegant drafting. Number 7 says unsigned employment terms and conditions dated 1st of March 2011. The elegant drafting would have been to put a comma or a semicolon after 2011 and the second one. There are 3 sheets.
So now there's a third sheet of paper. There's a third
No,
sheet.
my lord, I'm coming to that.
Yes.
I'm saying, sir, that second, what is it? On unsigned employment terms and conditions, that is page 1.
Yes.
That is the one that is dated March 1st,
Yes.
2011.
Yes.
I'm saying that if I had drafted it more elegantly, I should have put a comma or a semicolon after 2011. Then the second one, and addendum, dated 1st November 2011.
Which would have been referring to the second page.
Yes, my lord. The second
Okay.
and third
Now the
pages.
third page. There is a
The
third
third
page.
page is a continuation
It's a
of,
continuation.
yes, sir.
Okay. Okay. So the relevant dates as stated on this list is
Yes,
that
my lord.
1st November.
1st of March and 21st of November and 21st of March.
And the unsigned refers only to the document
The
1st
1st of
March
March.
2011.
Yes, madam. Yes, madam.
Mr. Majori.
Yes, my lord. They made reference to the documents. But that document they're making reference to
Yes.
is not before the court. The document they refer to, dated 1st of March, it's not before the court.
Let us see the document is tendering. The document we have tried to explain now is before the court. We have a document, employment terms and conditions, and there is a date, 1st March 2011.
As the court pleases.
I don't know what I have, my lord.
You just confirmed that now it's out from paragraph, the addendum, the first paragraph of the addendum.
After the email,
Yes, my
you
lord.
confirm that there's a page. The
Yes, my
heading
lord.
is employment terms and conditions. And paragraph 3 refers to the effective date as March 1st, 2011.
As court pleases.
That is the date they have referred to in their list of documents.
As court pleases.
And the second date document has, which they called an addendum, and it is dated 1st November 2011, which is also this next sheet of paper.
As God
Yes.
pleases.
Or it only continues this signature, in my view, this date of signing, this second page is not unsigned. And what Leonard Senior is saying that if there was a semicolon, it would have been clear that the one containing the signature is different from the one that is referred to as unsigned.
As God pleases me. We are not clear, but hopefully if the document goes in, they will
Yes.
clarify in the written address.
Yes, in the written address, because from what I have here, our main concern is to make sure that we have the same documents and that you will accept the documents.
As God
So
pleases.
what the document is trying to tender, provided it is what he has concluded, the
As God
effect becomes a different thing.
As God
So we
pleases.
have confirmed that you have number 7.
As God pleases.
Which other one do you not have?
The other
Apart
documents,
from 13, 14, 15, and 16, you have the other documents.
yes, my Lord.
All right. So let him tender what he has. And we note that he has not tendered 13, 14, 15, and 16.
As
So we
God
continue. There's no law that says he must tender everything as listed.
as God pleases.
So now that we know the documents that are going to be tendered, so I'm now saying that the witness says I referred to some documents in my evidence. They are listed in the list of documents. I do not have numbers 13 to 16.
13, 14, 15, and 16. Yes,
Yes,
ma'am.
13 to 16. Yes, Mr. Majoy.
Yes, my Lord.
Yes. Let's have the document, sir.
Yes, ma'am. My Lord, I've also taken time to flag each by the number on the list.
Yes, Mr. Manjoy.
Sorry, my lord, I'm sorting out the document. Yes, my lord. We have taken a look at the documents. We are objecting to.
My lord, I have not said I was tendering the documents yet. My learned friend started out by saying that he does not have some documents. That's what we just sorted out. I will still need to put the documents to my client because there are some of them for which he needs to lay foundation. It's not got to that stage. I have not said I was tendering.
Okay. Return the documents to.
Your lordship gave it to him so that I can confirm that the documents I'm tendering tally with the one he has. That's why we have.
Okay.
Court, please.
Thank you. So, my lord, with what has just happened, I crave your lordship indulgence to go one by one because I would need to lay foundation as a court proceeding. Mr. Second, can you still hear me?
Yes, I can.
All right. The first document you have by the list is the ruling of this honorable court dated the 20th of May, 2019. This is a certified true copy from the court, yes?
Yes, sir.
Thank you. My lord, we seek to tender the document listed as number 1. It is needed, it is relevant, therefore admissible.
Yes.
Yes, my lord. The witness has seek to tender a said document without even making reference to the paragraph where the alleged pleading document was founded. He just identified the document and same was pleaded and is relying on.
He sought to tender the ruling of the court,
Yes, my
the
lord.
certified true copy of the ruling of the court,
Yes, my lord.
and he did not refer to the paragraph. Is that a ground for objection?
Yes, my They are likely to, we just said that the document was pleaded. We have not seen the paragraph where it was pleaded.
So are you objecting on that ground so that I'll record you that you're objecting because it didn't refer you to the paragraph?
Yes, my lord, witness has not led us to the paragraph where the document he seeks to tender is being pleaded.
This process that was served on you since 2019, you do not know whether it is in the pleadings or not. You want the claimant does not refer you to the paragraph, then you will object on that ground. Then I'll record it and rule on it.
As court please, we withdraw our objection. We are not objecting to the ruling of the court.
Miriam.
Did you get all the documents back? Thank you. Get the documents.
Miriam, the other documents. The other documents. And let him go. Okay.
If you have some documents.
No.
Yes, if any.
Yes, my lord. Yes, I'm just trying to arrange the documents by the leave, but I'm still I'm struggling to read this thing. There are some documents that were here that I can't seem to find now. Just to. Right, my lord, I will continue when I get there.
Yes, please continue.
Yes, sir. This is the second document is your affidavit of change of name dated 17th July 2011 and 12th of August 2016. You confirm that the document you have here is a photocopy, isn't it?
Correct, sir.
Where is the original? Why is the original not in court?
Due to my relocation and moves, I searched for the original copy, but I seem to have I couldn't find it.
All right. My lord, we seek to tender the photocopy as secondary evidence of the affidavit of change of name sworn on the 17th of July 2011 and that sworn on the 12th of August 2016. Registrar.
No objection.
Yes, if any.
Yes, ma'am. Second, the next document on your list is an email from Bonita Agbomeke dated the 19th of May 2008. Is that so? Madam, can you hear me, ma'am? Second.
Correct, sir.
Right. Now, this affidavit, you equally forwarded to your husband on the 7th of June 2019. That original email, is that correct?
Correct, sir.
This is an electronic mail and you seek to rely on it, correct?
Correct, sir.
My lord, you seek to tender this document and everything.
No objection.
My lord, the next document is that listed as number 4. Mr. Second, this is an attachment to the document that we just tendered, the email from Bonita Agbomeke. Can you confirm that you printed this attachment from the email that was sent to you from your computer device?
Yes, I confirm.
My lord, we seek to tender this document. It's listed as number 4. It's needed, it's relevant, but this.
No objection.
The next document, Mr. Second, is listed as number 5. It is the now second defendant backdated letter dated 30th of May 2008, and the contract executed with the second defendant on the 24th of June 2008. Can you confirm that?
Confirm, sir.
All right. This letter and the attachment are also copies. They are not originals. Can you tell my lord why the original is not there with me in court?
Again, I was unable to find the originals.
Thank you. My lord, we seek to tender the photocopy of the letter dated 30th of May
So
2000.
she was not given the originals.
No,
I didn't-
was that what you
I
said,
was,
Mr. Second?
What did you
I was
say?
unable to find,
Okay, you were
I
unable to
searched
find
for,
it.
but unable to, yes.
She said she was unable to find them. Thank you. Mr.
Yes.
We seek to tender the document listed as number 5 on the list.
No objection.
Next on your list, Mrs. Eken, are emails from the claimant
Yes.
dated and communicating their timesheets to you, and the timesheets are also attached. Is that correct?
Correct.
You confirm again that you printed this from your computer device?
Yes, sir. Confirmed.
My lord, I seek to tender the document listed as number 6 on the list.
Lord, will be objecting to this said email. The claimant has alleged that there was an email communication between herself and first and second defendant. But this email on the face of it is not between the claimant, first and second defendant. It's not relevant, but the correspondence here is between a party. The first and second defendant is not listed in this email.
Yes, Chief Alan. And then
Yes, my lord. First, my lord, I submit that at this stage of the proceeding, what determines which document goes is if it was pleaded, if it is relevant, and then it is admissible.
it was pleaded,
It was pleaded, if it is relevant to the issue at hand, then it is admissible. My learned friend's argument in opposing this document goes to weight to be attached to the document and not the admissibility of the document. It is settled there. I refer my lord to page 34 of the bundle, paragraph 16 of this witness's statement on oath. This document we seek to tender
page
is clear.
34.
Yes, paragraph 16 of the witness statement of oath. This document we seek to tender is clearly stated there. Now, whether it goes to show or prove what it says it goes to show or prove is a matter for address as to the weight. But whether it is admissible, it is clearly admissible. And I submit that your lordship to his countenance of judge.
Yes. Someone to, do you still? He has responded.
Yes, my lord. We leave it to the court for ruling.
Yes, I find that the documents are pleaded and they also appear relevant. I therefore admit the document. Counsel can further address on the way to be attached to it.
Court, please.
As a My lord, the next document on our list is number 7, the very famous number 7 that caused us some delay this morning. Mr. Secretary, can you confirm to my lord that this document listed as number 7 are 2 documents, one dated the 1st of March 2011 and the second dated the 1st of November 2011. Can you confirm that?
Yes, I confirm that, sir.
Can you also confirm that the first one, the first page, is the one that is unsigned? That is the one of the 1st of March 2011, but that of the 1st of November 2011 was signed by you. Can you also confirm that?
Yes, I confirm that.
Finally, these 2 documents are photocopies. The originals are not in court. Can you explain to my lord why the originals are not there in court with us?
Yes, the originals are not here because I searched for them everywhere after my relocation and I can't find the original.
Thank you. My lord, we seek to tender the document listed as number 7 on the list.
No objection.
Thank you, my lord. The second, the next on your list and mine and the court should be the email of the 28th of January 2015 from the second defendant, Judicial, to you. Can you confirm that? You need to unmute yourself now.
Oh, sorry, I didn't realize I was muted. Yes, I confirm that, sir.
You also confirm that you printed this from your computer device.
Yes, I confirm that.
We seek to tender the document you have listed as number.
No objection.
Sorry. Mr. Secretary, the next one is number 9 on our list. It is a letter dated the 12th of February 2015 from the second defendant made for your attention, which also attached the purchase order contract number 450-109-5441. Can you confirm that, please?
Yes, I confirm that, sir.
This again is a photocopy, not the original. Can you tell my lord why the original is not important?
The original is not available because I searched for the original after my relocation, but I couldn't find them. I couldn't find it.
Thank you. My lord, we will seek to tender this document listed as number 9.
No objection.
The next document witness is the one listed as number 10 These are some of the pay slips issued to you in 2015 by the second defendant. You confirm that, correct?
Yes, I confirm that.
And this came to you in an email from the second defendant to you. Confirm that.
Yes, I confirm that.
Do you confirm also that you printed this email from your computer device
Yes, I confirm that.
and that it attaches several payslips of the payment that was done to you by the second defendant?
Yes, I confirm that.
My lord, you seem to tell me that this
Check.
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 Objection.
The next document witness is the email of one Titi Lion Ogunjobi, Titi Ogunjobi, dated the 15th of July, 16th of July, no, sorry, dated the 15th of July, 2015, with the subject addendum to contract, which also attached an addendum dated the 1st of June, 2015. Can you confirm that? Please?
Yes, I confirm that.
Can you also confirm that you printed this email from your computer device?
Yes, I confirm that.
My lord, we seek to tell you.
Objection.
The next document is the second is an email from this same Titi Ogunjobi, dated the 16th of July, 2015, and another email dated the 22nd of July, 2015. Do you confirm that you printed this email from your computer device?
Yes, I confirm.
My lord, we seek to tender this document. Contains emails as listed, 15th of July, 2015, and the addendum, sorry, my lord, and that of 22nd of July, 2015.
Objection.
So, Mr. Second, I want to skip some documents on the list. We'll come back to that later. I'm skipping 13, 14, 15, and 16. So I'm going now to number 17. It is an email dated the 17th of February, 2016. 17th of February, 2016. It is an email from the third defendant to you. Can you confirm that, please?
I confirm that.
From one Dennis Kelechi. Confirm?
Yes, I confirm that.
Can you also confirm?
What date is on the email?
17th of February, my lord.
17th February.
Yes, my lord.
What?
2016.
Yes.
Can you also confirm that you printed this from the computer device?
Yes, I confirm.
My lord, we seek to tender the document you have listed as number 17.
Yes.
No objection to the email, my lord.
Exactly. The next document I'm going to is that listed as number 18. It is a letter, a contract letter dated 16th of February 2016 from the third defendant to you. Can you confirm that?
Yes, I confirm that.
This letter I have with me in court is also a photocopy, not the original. Can you tell my lord why the original is not in court?
Because I searched for the original after my relocation and I couldn't couldn't find the original, so that's why there's a copy.
Thank you. My lord, I seek to tender the document you have listed as number 18.
No objection, my lord.
I go to the next one on your list, Mr. Secretary, which is listed as number 19. It's a referral letter of one Dr. Okezie Obasikane, dated just a minute, madam. Dated the 2nd of October 2015, which also attached receipts from the Children Health Care Center in Atlanta, United States of America. Can you confirm this?
Yes, I confirm this.
This letter was written to the pediatric neurologist of the Children Health Care of Atlanta, Georgia. Is that correct?
That's correct.
It was not written to you.
That's correct.
But the subject matter is one Eken Inor, female, born on the 5th of July 2013. Is that correct?
Yes, that's correct.
What is your relationship with this Eken Inor?
She's my daughter.
So can you confirm to my lord that you came across this letter because it concerned your daughter and a copy was given to you?
Yes, I confirm.
My lord, we seek to send that document listed as number 19.
Be objecting vehemently to the said document on the following grounds.
Yes.
Yes, my lord, this is a document coming from public institution, being a public document ought to be certified, and also this letter was addressed to the pediatric Urologist Children Healthcare of Atlanta. The letter is not relevant to this proceeding. It has no connection with the employment of the claimant and the proceedings of today. There's no relationship anywhere between this said document and the subject matter in court today. Also, my lord,
Yes.
being a public document not certified, the proper person to tender this document is who made the document or to whom it was made. Who can speak to the authenticity of this very document? It was not made by the claimant. It was not addressed to the claimant. It is not a part or parcel of this proceedings. It's not relevant and also has not passed the admissibility test. The asking should be marked, tendered, and rejected. It's not relevant to the proceedings and has no connection with this proceeding. There's no anywhere that has stated that one Ekeng Zinora is part of this proceeding. There's no contract. It's not related to the claimants. It's not related to any of the defendants in these proceedings.
Yes, Chief Adeni.
Yes, please, can I have it? Thank you. My learned friend's objection, if I got it correctly, is premised on the following, and I'll address them seriously. That the document we seek to tender is a public document. My lord, what is a public document? A public document is a document that is within the custody of an authority for which certification is required. This document, as stated clearly by the witness, is from the Lagos University Teaching Hospital to an hospital in the United States of America, where the daughter of the claimant was referred. My lord, the second ground upon which you have objected.
Your submission is that it's not a public document.
No, I want to tie everything together.
Okay.
Yes, thank you, madam. The second ground, if I got it right, is that the claimant is not the addressee. But in the foundation that she laid, she had confirmed, one, that the subject of this letter, one Dinora Eken, is her biological daughter. Who was referred to an hospital in the United States of America, and that this document came into her possession because a copy of it was given to her. My lord, the scenario is simple. If you are taking your ward to an hospital, you get to have the letter to take to that hospital. That letter cannot be addressed to you, but you will be the custodian of the document in the final destination. Finally, my learned friend said it is not relevant to this proceeding. However, with respect to page 47 of the bundle and paragraph 63 of this witness's deposition. It is clearly stated.
Page what?
Page 47 of the bundle, my lord, and paragraph 63, 64 of witness statement on oath, which has been admitted in evidence. Another paragraph 63 speaks to the fact that this letter was issued as a referral for her daughter. The admission of that daughter in the United States of America. The receipts that are attached to these documents are also clearly stated. And in paragraph 64, she testified of her return after this procedure to Nigeria, and that she spent all her funds to settle this medical bill. Her claim in this case is also that these expenses should be given to her. So whether it is relevant or not, my lord, the pleading speaks to its relevance. And that is what governs admissibility. My lord, this document is admissible. And it is not a public document. It is not a, I'm not finished. It is not a public document. Because it is on the letter-headed paper. The personal letter-headed paper of Ms. Dinoreken's doctor. It is not from public custody. Therefore, it is not a public document. I therefore submit that the objection is misconceived, to be dismissed, and this document be admitted in some basis.
Yes, I should go ahead.
Yes, Mr. We reiterate that the documents cannot pass the admissibility test. Even in the recent just completed election petition case between Atiku and Tinubu, the Supreme Court said, if you are bringing in a document that does not originate from the source of the issue in question, even by difference, especially when it is coming from outside the organization, it must be registered and it must at least, if you can't get it certified over the US, we have embassy. That was the Supreme Court ruling. When they were article trying to bring in the drug issue, the copy, even the certified copy that was gotten from the United States Court, the court rejected it on the ground.
The United States Court is a public institution.
Lord,
The United States Court is a public institution. And so any document from the US court should be certified. But I'm looking at this document. It's a
Nigerian document.
it's a letter from a medical practitioner in Nigeria where he wrote his name, Okezie Obatikan. Then the University of Lagos just happened to be his address. It's not a document emanating from University of Lagos.
On the face of the document, this same document was written and taken outside. It was sent to Georgia, USA.
So who should certify it now?
The document is being returned. It was not sent to the claimant. We are getting the document from the receiver, which is the Children's Healthcare of Atlanta.
No, the evidence of the claimant is that she got a copy.
There's nothing before the court to show that whoever this is the doctor.
Okay, I'll rule on it. You know, so that we don't keep dancing around it. There's no evidence that Ekong Dinora is her daughter. There's no, I've been quite patient with the process we are going through because I don't want any party to feel that he was not given opportunity to make his points. But while we do that efficiently, we must also note that, there are things when we raise it, we overreach ourselves and overflow it. There is no evidence before this court that Eken Dinora is her daughter. Does that make it non-admissible? It's a matter for address. If it's admitted, you say that you speak to it, that it's not even the daughter.
We have said the letter wasn't addressed to the claimant.
Okay, so we should stop arguing and let me just rule on it, and then
As the court pleases.
continue however I rule and whatever position you
As the
take.
court pleases.
It has already been recorded. But my view is that this document, this paper is not a public document. That's my view. If I write a letter in my personal name and use National Industrial Court as an address, that does not make that document a public
As the
document.
court pleases. As the court
I would do that every day. I still write, in fact, when I rose, I had to sign a referral letter for a student. I signed, recommendation for my former students. I signed it in my name. I use National Industrial Court, which is where I work now. So if somebody seeks to tell that you say because my address is National Industrial Court, it becomes a public document. That's one arm. I'm just not addressing it or responding to it. I'm just making an observation on that one arm. That's just the point.
Register.
You saw his article and Tinubu. And some of these things we object to there. Some of them don't even go to the real cause of action.
And that's why it's
So
not
some of them-
necessary. That's why it's not necessary.
It may not go to the real cause of action, but it's pleaded and it's admissible and can be taken. But it really adds not much to the claim.
Putting it to the externals to the councils that will respond, they can addressing issues that are not relevant.
What is strenuous is when you keep raising unnecessary objections. You have to write on it, and the court will have to write on it, and it adds nothing. As you just like this 1 hour, we have spent more than 1 hour on this thing. We have been sitting here more than 1 hour.
This sorry for stressing a lot.
No, forget it. Going one by one, and we've achieved nothing. All the documents will eventually go in.
As the
And
court
we
pleases.
just stress ourselves for more than 1 hour. Some of the documents won't even be considered, won't even be looked at. We just stress ourselves. Your client is not even here, so that we say that he see you. We just stress ourselves. We just stress ourselves for nothing. The documents will go in. We'll consider with them. The one that is useful, we'll use. The one that is not admissible, we'll discard. The one that adds nothing, we'll discard. You speak to this document. So we see that we take 2 hours and we just harass ourselves and we get nothing. Really. But it doesn't affect my view on the case or anything. It's just my opinion. We've been here for more than 1 hour. Just on admissibility, taking them one by one. I did nothing. I'll eventually admit all of them. During judgment, the one that is not relevant will discard. The one that is relevant, we'll look at it objectively. Nobody is a dummy. That's everything. But when we take 3 hours to admit documents, how many hours will you take to write judgment? And that's why this new practice direction was introduced
As the court pleases.
to ease off all these things. Note as you're filing, list your documents, tag them, which one, lay the foundation there. Or sometimes you take 1 hour to lay foundation, and we take 2 hours to address the not laying of foundation. That's we had a ruling on this practice direction. So mark it so that when we just come, we admit and we move on.
If the process has come rightly, we'll be, if on the process itself, the foundations were not laid, if foundations were laid, we won't be object. We are waiting on them in the background, and they are laying the foundation orally. Sorry for stressing the court.
No,
It's on the
it's
framework.
okay. It's the job, isn't it?
It's on the
And
framework.
we'll do it patiently. But it's just an observation.
If the process was right, we won't be
Because
stressing
when we
enough.
started off with reserve your objections. That's what most councils do. And then at the end, you see that out of 20, you're actually speaking the fight.
We would have resolved because we don't like taking the claimant unaware. But they didn't lay foundation. In the written address, people have said that the whole document will go out. But we need justice. Well, therefore, we're going to go lay the foundation by written this. But then we'll continue to do.
What paragraph did you refer to?
Paragraph 63 at page 47, my lord. Page 47 of the bond. Paragraph 63 and 64.
Yes, I've looked at the documents objected to, and I'm of the opinion that the medical record is not a public document. It is signed by the doctor in his personal letterhead. Further, the witness said the doctor gave her a copy of the letter because it concerned her minor daughter. The medical documents from Metro Atlanta are all either addressed to the claimant and or relate to her infant daughter. I find the documents pleaded at paragraph 63 and 64 of the statement of facts. It is therefore relevant, pleaded, and hereby admitted.
As a purpose. It's second, the next document. Malana Frank just informed me that we will not be objecting to the
Not to waste time of the court. We don't intend objecting to any of the other documents left. That's one to labor the court.
You're already labored, so we can conclude the laboring. You're not doing us a favor at this stage.
This already Lord. We have actually marked this one as not to object them.
Not to object, okay, that's numbers 20, 21, 22, and 23.
As court pleases me.
Yes, madam. 20, 21, 22, 23.
The documents are marked as the C1 to C20. In the order they are listed. The C20 because 4 documents have not been tendered. That's numbers 13, 14, 15, and 16.
As a copy.
We have C1 to C20.
We are grateful. My lord, at this stage of the proceedings, I would like to ask for an adjournment. And this has to do with documents listed as 13, 14, 15, and 16. Hello, the challenge is that given the length of years, the documents are too bulky, but I'm sure if my litigation officer brings them to the registry of this court, they will chase him in. So we're trying to see if we can arrange with the banks to give us a precise form of the statement. Well, we've been at this for about 4 months. I discussed with my client, and maybe what we will do will be to bring an application to pin the banks to do the right thing. My lord, there is absolutely no way we can bring the items listed 13, 14, 15, 16 to this court because my client does not have those copies without anymore. The only route is to go to the bank. We have applied, we have followed up, but they have not been as cooperative as we expected. That is the reason, my lord, why we cannot bring those documents listed 13 to 16. And it's for this reason that I'm humbly applying for an adjournment, a short adjournment. If at the end of the day, my lord, we do not get these documents, then we will take a decision in-house as to how to go about it, to do what we need to do. I'm grateful, sir. I can't hear you, sir.
Give them a long day so that they can study with the bank. So that by the time you're coming, you would have taken all your decisions.
Yes, my lord. Yes.
April. Give them an April. April, by April, you should have sorted out everything.
Yes, ma'am. By that time, we'll know what to do. I'm grateful to the community. My Lord, the 17th of April is convenient for me.
Okay, Mr. Amadou, 17th April.
Convenient for you.
Adjourn to 17th April for continuation of
So as a court, my Lord, we are grateful to the court. We do not take it for granted. We are grateful to.
stop putting it in market. You have to be very careful. Are you the one that must come to
My Lord,
once you were in court today, you have to
my Lord, can I apply that the claimant can leave the meeting?
yes, yes, you are done.
Second, thank you so much. You can leave now. Thank you. Your matter has been adjourned, further adjourned. I'll get in touch with you later. You can leave now.
Okay, thank you.
Thank you.
Most grateful, my Lord. We will seek our Lord's permission to appeal the
If I quit, I'll have less than 3 lawyers in court.
At this time,
Huh?
we are keeping you online, my Lord.
Sorry?
So we have some lawyers
Is that not
online,
what
my
the
Lord.
rules say? You can't leave the
We
bar.
are happy to spend time with my Lord.
You should spend the time with us. You should stay here. Eh? You are the one that has kept us beyond this time. We have all reason and gone to do other things. But
I'm happy
the
to
rules
be my
say,
Lord's presence.
eh?
Happy to be my Lord's presence.
Thank you. So call the last case.
Yes.
Yes, I
Respectfully,
can see
okay.
there was an Ibili, Juliet Ibili, I can see.
Yes, yes, my lord, she's online.
What of defendant?
The defendant is now in court, my lord.
Appearances?
Respectfully, my lord, Ujunwonwu for the claimant.
Yes, Miss Wong.
My lord, today's matter is slated for hearing. Subject to the convenience of the court, we are ready to proceed. Mrs. Sibili, can you hear me?
Yes, I can hear you.
Okay, good.
The defendant voice. The defendants have always been served.
Yes, yes, my lord.
Mr. Ibili,
Yes, my
if
lord.
you have a Bible, you need to either swear by the Bible, Quran, or affirm. Which one do you do? Which one will you want to do?
I'll affirm, my lord.
You have to listen to the registrar.
Okay, thank you, my lord.
Check. Where will you go and read their permission? Use our counsels.
Yes, you repeat after me as I
Okay.
recite. So, you mention your name.
I, Juliet Ibili,
affirm that the evidence I shall give
affirm that the evidence I shall give
in this case shall be the truth,
in this case shall be the truth,
the whole truth, and nothing but the truth.
the whole truth, and nothing but the truth.
Yes, counsel.
Okay, please state your name, address, and what you do for a living.
My name is Juliet Ibili. I live at number 9 Onowale Street, Irakari Estate, Isolo, and I am an accountant.
Where are you giving evidence from?
Virtually, my lord.
Yes. Where are you giving evidence from? Where are you currently?
Okay, I'm in the UK currently, my lord.
Let's have the address, the full address of where you are.
Okay. 61 Templar Drive.
Debla.
Templar.
Can you spell it?
TEMPL AR Drive.
Drive.
DRIVE. Yes, my lord.
Yes, where is it?
Thamesmead.
Sorry?
THA.
THA.
Yes, my lord.
Okay.
MES.
Thames. Okay.
MEAD.
Yes.
London.
Yes.
Do you know the defendant in this suit?
Yes, I worked and resigned from the defendant company in 2015.
Yes.
Do you remember filing your further witness statement on oath alongside other documents dated the 10th day of May 2023?
Yes.
What date, please?
That's 10th day of May 2023. Hello.
It is an amended.
Yes, my lord.
Yes.
What do you want the court to do with the statements on oath deposed by yourself?
I want the court to admit and adopt same as my evidence in this case.
Yes.
Okay, on the furthest witness statement on oath, you have list of documents you relied and made references to. My lord, subject to the convenience of the court, I was thinking I would lump everything together so that I wouldn't waste the time of the court.
But if there's anyone that requires laying of foundation,
Yes, yes, of course, of course, of course.
Yes.
Okay, in paragraph 5, You have a letter of offer of employment dated 16th day of June 2009. Am I correct? Can you hear me?
Yes, I can hear you.
Okay, I said in paragraph 5 of your further witness statement on oath, you
Yes.
have a letter of employment dated 16th day of June 2009. Am I
Yes.
right?
Yes.
Okay.
Yes, go ahead.
Okay. In paragraph 6, you have a letter of promotion and salary adjustment dated 17th day of March 2014. Am I right?
You're right. Yes.
Okay. In paragraph 8, you have your letter of resignation via mail dated 8th day of July 2015. Am I correct?
Yes.
In paragraph 9, we have the letter of acceptance of resignation from the defendant, which was addressed to you, dated 30th July 2015. Am I right?
Yes.
Okay. In paragraph 12, you have 3 documents there. There is a letter of demand dated 29 July 2016
Yes.
by your solicitor to the defendant.
Yes.
What we have is a photocopy. Where is the original? Can you hear me?
Okay, yes. It was an email.
No. Listen carefully. There is a letter of demand that your solicitor wrote to the defendant. What we have is a photocopy, not the original. Who is with the original?
A letter of demand from the solicitor to
The defendant. Who is with the original?
The original should be with the defendant because it was addressed to them.
Okay. We also have photocopies of 2 checks. One
Yes.
dated 5th day of December 2016 and 27th day of October 2017.
Yes.
We have photocopies. Where are the originals?
The checks were presented to the bank for clearing.
In paragraph 15 of your further witness statement on oath, we have your retirement savings account statement for the period of 1st January 2004 to 15 December 2022 with Stanbic IBTC pension managers. Am I right?
Yes.
Okay. Now in paragraph 29, you have 5 documents. These are letters of non-remittance of pension that you wrote to National Pension Commission. The first one is dated 14th June 2018. Okay. The second one is dated 28th September 2018.
Yes.
7th March 2019.
Yes.
15th December 2020.
Yes.
And 13th August 2021.
Yes.
Okay. In paragraph 30, you have responses from National Pension Commission. 3 responses, 3 letters as a matter of fact. One is dated 3rd July 2019.
Yes.
5th January 2021.
Yes.
And 19th August 2021. Am I correct?
Yes.
In paragraph 34, you have a letter of demand which was written from your solicitor to the defendants. Am I right?
Yes,
We have a photocopy. Where is the original?
it's with the defendant because it was written to them.
Okay. Then we have the receipt of the courier that was used to send it. Am I right?
Yes.
Okay.
These letters of complaints, do you have the originals?
Yes,
The
my lord.
letters of complaint to National Pension Commission.
Yes, my lord. We have the original. Yes, my lord.
Let's have the copy.
My lord, we seek to tender all the exhibits attached as our evidence in this case.
The letters of complaint. And some of them in form of email. The letter of
Yes,
complaint.
yes, my
Some
lord.
of them are in form of
Yes, ma'am.
email.
I'm sorry, I forgot to mention some of them were email.
Do you have
Them were
any
email.
certificates to back them?
Sorry, my lord.
Certificates. Do you have any certificate to back them?
We filed a certificate of compliance with that, ma'am.
Sorry?
We filed a certificate of compliance.
filed?
Yes, yes, ma'am.
That's it. That's it. The documents are admitted. The documents are marked as C1 to C9. In the order they are listed. And C5 has A to C, C7 has A to E, C8 has A to C, and C9 has A and B.
As the court pleases. What do you want the court to do with all the exhibits as attached? Mrs. Sibili, can you hear me?
Yes, I can hear you.
Okay, what do you want the court to do with the exhibits?
I want the court to admit them as my evidence in this case.
What do you want the court to do for you?
I want the court to grant my claim as stated in my complaint and give judgment in my favor.
So we'll take another case for cross-examination.
My lord, sorry, can I draw your attention to the claimant to paragraph 21 of the claimant's witness statement on oath? Paragraph 21, my lord.
21.
Yes, my lord. My lord, in that particular paragraph, we mentioned the issue of pay slips, which is very, very crucial to this case. Unfortunately, those pay slips were generated by the defendants and is currently still in their custody. We have issued a notice to produce on them, for them to produce the pay slips. They have not been coming. We've been having hearing notices for them to show up. Unfortunately, we have not heard anything from them. So, my lord, my prayer is that I'm urging the court to deem all the evidences that is before this honorable court as uncontroverted and unopposed.
That would be for your final address.
Final address. As the court pleases. As the court pleases. I just wanted to draw the attention of the court to it.
It is for your final address.
As the court
To
pleases.
make your submission, draw your inferences.
As the court pleases. As the court pleases.
Children, date for cross-examination.
convenient.
The matter is adjourned to 20th March for cross-examination. Hearing notice to be served on the defendant.
As the call pleases. Oh. Can you hear me?
Yes.
Yes, you can go. You can shut down.
Okay. All right. Thank
Yeah,
you.
John, the next thing is for cross-examination to see if they will come. Okay. If they don't
Okay.
come, I will apply to the court to foreclose their right to defense. Then we go
Okay.
for judgment. Okay.
Okay.
All right.
Okay.
Take care.
All right. Thank you. Bye.
If people kept one in court today, and one for you, yeah? No, of course, he has the right to do so. Wow. Well, I don't get lunch. Oh. Wow, I don't want to.